Hey everyone, Jake
And Paul.
here with a quick and friendly request to rate and review Lawsome wherever you find your podcasts.
Ratings and reviews are like food for the show, and we all know how important food is.
Real important.
So if you like Lawsome, please show your support and keep it fed.
Thanks.
When it comes to quotes on writing, Tom Waits has a doozy. The world is a hellish place, and bad writing is destroying the quality of our suffering. The professional experience of law is so immersed in writing and reading comprehension that lawyers probably feel like they have a front row seat in hell with Tom Waits. Whether it's dispassionate afference in an affidavit or a lack of brevity in a brief, words are the tools and the frustrations of the legal workforce. Lawyers work with words and get paid for it, so lawyers are actually professional writers. That's what we're talking about today on Lawsome. The right stuff, legal writing, and the balance between law and life. What's the single biggest obstacle preventing quality written advocacy? Why should the term work-life balance be abolished? And why are contractions in legal writing a labor of love? All those questions and more coming up on today's episode. Let's go.
Lawsome, the podcast for law firms. Powered by Consultwebs.
Welcome back to Lawsome, the only podcast for law firms that thinks BYOB means bring your own briefs. We're here to inform, educate, and entertain the legal community on the latest in personal and professional development. I am your co-host, Jake Sanders, and I'm a little bit country. And joining me from Chicago is Paul Julius, who is a little bit rock and roll. How are you today, Paul?
All right. I'm jealous that you're a little country, though. I always thought of myself as a little country. Maybe that's
my teeth aren't real. Your teeth are real.
I'm okay with the rock and roll.
I bet a lot more rock and roll people have fake teeth. Country kind of seems like I'm flossing. I'm gonna, what's on the show today?
All right. On the show today, we cover an article about law-life balance from lawpracticetoday.org. We sit down and chat with legal writing guru Caroline Mandel, and we place Caroline in the precarious position of having to answer 10 questions we ask everyone.
Pull up a plate. It's the Hot Takes Buffet.
The link today is from lawpracticetoday.org. It's Balancing Lawyers' Time and Life by Roberta Tepper. She works with the Arizona State Bar. Very solid article with great tips that every workaholic, which is every lawyer, needs to hear. Kind of briefly, it's unplug. Get off of your phone, get off of your computer, kind of set away times. Schedule that downtime. Having an accountability buddy, someone to help, you go through this journey of law, and focusing on health and wellness. I think they're all logical tips. Did you have any reflections on this, Paul?
I liked the it's interesting to me that the unplug and wisely invest in and use technology were one right after the other. I think there may be something like how you can use one to make the other happen. I'm a very big proponent of being offline at some point. I mean, I remember back when, we didn't have cell phones, so it was just it's out of the office. I think that was valuable time that it's not such a great thing that it's not here anymore. And so I wonder if there's a way, and that's no one's ever really away from work now. We talk about this later that, with the phone, you're always a text away. And it's getting to the point now where if you don't reply within a set time frame, it's rude, which is odd. Like I've had people like, I didn't have my phone. I just didn't have my phone because I didn't want it. I'm with anybody who I would need to talk to right now. That's not an acceptable thing anymore.
Right. And I think that someone that shows up saying, look, I'm going to have to be really strict about my office hours. Work-life balance is really important to me. If you say that at your first day at the job, that might be the last day of your job, where they're like, you prissy millennial, avocado toast eating, what? You can't handle this? But you brought up a really interesting point, is that unplugging the tech and using the tech to unplug kind of our problems maybe contain the solutions. Like the things that are kind of driving us crazy, if you just use them in a different way, maybe can solve that issue. Is that kind of what you're saying?
Definitely. We know for a fact that majority of firms, solo small firms, don't use practice management software. So all that document management, all that stuff, it's not efficient. If you're constantly having to review the process as opposed to actually be the lawyer, of course you won't be able to unplug, because you have to, because everything stops if you unplug. So that's just one kind of an example. I mean, there's lots of, even backing up into business stuff, things like QuickBooks, things like having a good phone system that can transcribe messages and send them to somebody. That kind of stuff is going to make administration of these things that it's not, one thing, answering the phone or whatever isn't gonna pull you down. But when you have 50 of these things with their hooks in you, it's just gonna drag you down.
But what you talked about, what is it? Optical character recognition, OCR. One of the things I did at an old law firm that I was at was making all of the paperwork scannable and searchable through optical character recognition. Whereas before we had to physically grab files and go through and thumb and look for words. If you take all of the paperwork in your administrative process and make it searchable through OCR, now you've just, what have you done? What time have you given yourself back? But telling people that optical character recognition is the way to do paperless as we're trying to transition, they didn't even understand. They're like, just give me the brief and I can get through it. So it's sort of like, just give it here. I don't have time to wait for your technological solutions to transpire. And I think that's really what it is that a lot of people maybe they do know that tech could help them, or maybe they do know that there's an option out there, but how would I be able to add this on? And that's why I think this article, the problem that I have is that the idea that all lawyers approach the career of law with logic in mind, like it was the logical output of their life. But life and your career doesn't happen logically. And I think relationships with law schools don't happen that way. And for many, finding out where progress is going or time's progress, it's not a discrete arrow that points in the direction where you're supposed to go. Life is more like a blob with a slowly revealing purpose. So needing to see things as logical, desiring that arrow can be stifling and difficult, but using logical frameworks like the ones that Roberta is suggesting that can help you roughly shape the blob and see where it's trending, that can help. To me, I think it's better to interpret this article as not how you can start doing more things, but how you can get a list going on, decide where you're going to be spending your time and be more efficient and drive value where you're most needed. So if you can come from that mentality and take these kind of tips, then you're good. But if you're thinking this is the way it needs to be, then you might, stumble and trip, or you'll be that, that, not the millennial, but, on your first day, you say, I don't work after 5. And they're like, well, we'll see you later. And we'll see you right now. Goodbye.
Well, it's interesting too. Something I got out of this. I've heard a lot. Nobody can multitask. Have a time management strategy. Those two kind of go hand in hand, where you say, okay, I'm only going to do, I need to break out these certain tasks into certain buckets and approach each bucket independently. I can't carry
Yep.
5 buckets at the same time. So
Mhm.
we're going to have to knock off each one. And I think it's interesting to kind of bring it back to what we're going to be talking to Caroline about is
Mm.
excelling at some of these things, and that will make you more efficient. So that bucket gets knocked out quicker. So if I'm a better writer, I don't have to revise this thing 6 or 7 times in order to get my brief done, without it taking up all day.
And she kind of brings in writing as one of those technologies or those skills that you can have and kind of hone to get your time back. I think, being better, being more direct, understanding what your audience needs to hear and, getting in and getting out. You can, as you work on that process, you'll be quicker. And then over time, maybe you can get your time back, by maybe focusing in on some of these, kind of seemingly unattached areas of law.
Well, for
but-
sure. And I think too, with the writing, one point she makes very early, and it's obvious, but there's so much writing that goes on.
Big time.
So why not look at one of the biggest chunks of things that you spend your time on and figure out a way to do that better?
That's a great observation. That
Thanks, Jake.
Well, you're welcome. But no, it's all writing. It's all kind of reading and writing comprehension. So could you find a way to achieve that work-life balance by getting that work done more efficiently or finding the ways that you can drive more value to the places where you can excel?
Absolutely.
Nice. All right. Well, so let's go to the interview. You guys are going to love it. And if you want to be country, you want to be rock and roll, it's up to you. Just make it to the show on time.
And now, a word from our sponsor.
I met Tanner, who works for Consultwebs, on a plane on the way back from Key West, Florida. And I'd just been thinking that I needed to do some more marketing for my law firm. So when he told me that he worked for Consultwebs, I was super excited. From the beginning till even now, I've been with them for almost 2 years, and the experience has really been great. Having Consultwebs on board is really like having your own team of people that really care about what kind of business you're getting. I mean, practicing law can seem kind of lonely. You always are wondering, how am I going to get clients? How am I going to make payroll? But with Consultwebs, it's not just me worrying about having people come in the door. They're there as well, and they've been so responsive. Since I started with Consultwebs, I have increased the number of employees double at least. And since I started with Consultwebs, the revenue has tripled. So it's really been an incredible experience.
Go to consultwebs.com to learn more.
And now, for a lawsome interview.
Caroline Mandel got her JD from the University of Toronto and worked as legal counsel in the Ontario Court of Appeal for over 10 years. Starting in 2017, Caroline started her own legal writing coaching business, helping judges and lawyers at all levels unknot legal problems and translate complex ideas into clear, persuasive prose. She's also an adjunct professor of legal research and writing at the University of Toronto's Faculty of Law. Her lovely prose on social media and frank advice on legal writing brought her to the attention of the Lawsome Podcast, and we are honored to have her on the show. Caroline, how are you today?
I'm wonderful. Thank you so much for having me.
Well, thank you for returning our call. Let's jump right into this. Explain your career path from legal counsel that loves writing to counseling lawyers on writing better.
So being a staff lawyer at the Ontario Court of Appeal is sort of a unicorn of a law job. It's an amazing combination of being able to do a ton of writing and also reading a ton of writing, in addition to being able to see oral advocacy whenever you want. So I was doing a lot of writing, both sort of, for your eyes only memos to the judges of the Court of Appeal, which is the busiest appellate court in Canada. It hears about 1,500 appeals a year in all areas of law, civil and criminal. So I was writing a lot of memos, and I was also helping the judges write their judgments, sort of talking through what the shape of it would be, what issue would go in which order. And then doing a really thorough edit of judgments. The court has law clerks, the same way as you're familiar with, who would do sort of the bread and butter work. And I sort of did it on bigger appeals. And so I really got a sense of what goes into crafting something that is going to reach a varied audience. And at the same time, I was reading this very high volume of legal briefs that were coming in. And I got, over time, sort of this light bulb went on for me that writing is not something that you're either born with or not. It's not, like people say, oh, well, I'm really artistic. You either kind of have it or you don't. I was so fortunate to work with Justice John Laskin, who is really sort of the dean of legal writing in Canada. And he would go all over the country speaking to every type of audience on how to be a more persuasive legal writer. And it was through him that I realized this is stuff that can be taught. And to the extent that legal writing has a bad reputation, it doesn't have to be that way. And so as I sort of reached my 10-year mark at the court and started thinking about what I wanted to do next, I knew that I wanted legal writing to be a part of it. And then the other thing that happened is about 4 years ago, the University of Toronto, my alma mater law school, developed a legal research and writing program, and they asked if I would teach in it. And have either of you ever had that dream where you are walking around your house and you discover there's a room in your house you didn't know was there before?
Most definitely.
Yeah. And that's what teaching was like for me. It was like, oh, there's this door that's open to me that I didn't know existed before. And it was just a revelation how much I enjoyed not just being in the classroom, but really working one-on-one with people and seeing them and sort of helping them and being their Sherpa up the learning curve was really satisfying. And so putting those things together is how I decided to branch out and become a legal writing coach.
Writing is a fundamental aspect to the practice of law, but you have some problems with the way law schools are kind of failing around this idea of fundamental basics around legal writing. I mean, there's tons of reading, there's tons of writing that goes on already in law schools. What do you feel that they're missing?
First of all, I don't want to be too hard on law schools. I think that it's a really, really hard thing to teach. It's difficult in sort of every dimension. So if we're looking at the first question, and lawyers like to think of things as threshold questions. So to me, the threshold question that many law schools grapple with is, why are we teaching this in the first place? A lot of law schools are sort of ideologically sort of conflicted about whether they are there primarily to teach law as an academic discipline, or are they there to teach law, to build professional skills so that people can go out and hang a shingle? And that's not an insignificant debate, I think. What is the balance between sort of the study of law for law's sake and the study of law to acquire skills to go out and be practice ready? Once you've decided sort of institutionally that you're going to teach the practical skill of legal writing, there's a tricky question about when do you teach it? Do you teach it in first year, where students basically have no context to understand why these skills are important? Or do you teach them at the risk of them sort of developing bad habits? Because let's be honest, a lot of the reading that you do, a lot of the foundational cases in law are not well written, right? So we're not exactly practicing what we preach. So there's this when question. And if you put it off until later, students might be less engaged, because law students, I think it's fair to say, by the end of sort of the middle of second year, figure they've learned everything there is to learn, and they're a little bit turned off. And there's also the question of whether it should be mandatory or discretionary. A lot of the skills-based stuff that goes on in law school is meant to be for people who decide that they're going to pursue litigation path. Once you get past those questions, there's a who question. Who should be teaching legal writing? Should it be practitioners? the people who are out there in the trenches every day actually doing legal writing. And just because you might be a good or successful legal writer yourself doesn't necessarily mean that those skills are going to translate to the classroom. If you're using adjunct faculty to teach legal writing, you have to recognize that to teach legal writing well, you have to be able to devote a tremendous amount of time to marking and giving feedback, because otherwise, what's the point? It would be like, if you don't have an opportunity as a law student to do a ton of writing, it would be like training for a marathon by watching somebody else run. You have to actually put on your shoes and do it. And then if that weren't all enough, I'm going to hit you with a bit of a paradox, which is the more robust a legal writing program a law school has, the potential is that it's misleading and it's giving students and their employers this sort of false sense of security that their toolbox has been filled with everything they need to go out and be successful legal writers from that point forward, when in fact legal writing is a skill that you certainly acquire hopefully in law school, but you should be going on to refine throughout your career. It's not like something that you pick up in law school and don't think about again.
So when you're talking about lawyers, you say that they're actually professional writers and they should start considering themselves as such. So why would a lawyer want to consider themselves a professional writer, and how could it help their career?
So this is one of the things that has surprised me the most in the time that I've been out there working with lawyers. I often will start by asking, whether it's in a large group when I'm doing a seminar or it's one-on-one, I'll say, before we start, do you have any background as a professional writer? And invariably, the answer is no. And so then I change the question and I say, okay, well, like, have you ever written in exchange for money? And still the answer is no. And these are litigators usually who I'm working with, right?
Yeah.
And so I say, okay, well, so remind me what it is that you actually like do all day. And then they have this, Oprah light bulb aha moment.
Oh, you're talking about me.
Right. That's what I do all day. I write email. I write affidavits. I write briefs. I write papers. That's what lawyers do. It's not all that they do, but all lawyers write. And I think it's really important for lawyers to see themselves as professional writers for a few reasons, and I'll give you 3. The first is that professional writers don't think they know it all already. I mean, I think professional writers are the stereotype is the writer who's sort of always feeling a little bit down on themselves because they hate that last sentence that they wrote.
Classic.
Yeah. And this is we're talking about writing, so I think I'm obliged to throw out a David Foster Wallace quote. Mm-hmm. David Foster Wallace said, "Good writing isn't a science; it's an art." And the horizon is infinite. You can always get better. Mm. So I think it's really important for lawyers to think of themselves as writers, insofar as writers are never satisfied and they're always looking to polish their skills. I don't know of a novelist who will say, once I wrote my first novel, I knew everything there was to know about fiction, writing fiction.
Yeah, stay away from that one.
Yeah, right. The second, and this is so important, writers know how hard it is to write. Writers expect to be in agony. They're pleasantly surprised when they're not. And this comes from my own experience, doing so much writing of my own and having this familiar sense of dread every time I sat down to the keyboard and saw that blank screen and the blinking cursor. Mm. And it took me a number of years to realize it's supposed to feel like that. That means you're doing it right. because it means that you're thinking about how are you going to construct this sentence or paragraph or, full piece of work in a way that's actually going to get across to my reader. There's this tweet that I really like from Emily Nussbaum, who's the New Yorker television critic, that I always show to people. And she says something like, this is rotting garbage that falls apart at the end with an arrow that says, me handing in all drafts to my editor. She's a Pulitzer Prize winning writer, so probably her stuff isn't rotting garbage that falls apart at the end. But it's very writerly to think of it that way. And I think that kind of humility is instrumental and useful.
Yeah.
And then the third thing is that because writers know how hard it is to write, because it's this uncomfortable experience, professional writers have developed a sort of series of habits that help get them through that process. And I think that there are a lot of those habits that once presented to lawyers, they can see how they can, with some small tweaks to the way they approach their own work, they can make the journey a lot more comfortable for themselves.
Oh, I love that. That's so brilliant. And as a professional artist, and, I've done my own bit of writing and stuff. And yeah, you have to have that feeling that your heroes are up there and they're just as nervous being on stage, and having to realize that rather than thinking that I have to aim for perfection, because perfection can be, what is that? The Voltaire quote, "The perfect is the enemy of the good." Like you want it so good that you'll never leave your house.
Right.
I know professional musicians who are amazing and no one knows who they are because they've been working on their opus. Or, it's like, you got to know when to just move away from the canvas. I love that. And lawyers should feel a little bit of that kind of looseness in the way that they approach words. I think there's a lot of strictures on the way that they handle it, but really good lawyers kind of have fun with it, sort of are like, word dolphins or something. That metaphor doesn't all the way. It's a flipper metaphor.
A metaphor for you.
What time is it? I'm looking at my watch. But if you're talking about these skills that need to be polished off every once in a while, get the white gloves out, make sure things are looking good. Why do lawyers and judges as well? I think that might be important for the audience to hear. Why do lawyers and judges both need to dust off those skills of the quill?
So if you think of going back to something, so if you're an artist, if you think back to some of the early work that you did, how does it make you feel?
Yeah, horrible, like garbage.
Horrible, right?
Well, sometimes it was really good. And you were like, man, I had that stupid, I had no fear. I was just making weird choices.
So that's actually great. That's both sides of the coin. On the one hand, your skin crawls because you want to go back and, fix everything that you now see through different eyes as, I was being pretentious there, or I was using words I didn't really, know what they meant. So there's that aspect to it. And then you're quite right. On the other side of it is, there was a looseness there. There was a playfulness, a willingness to experiment that I've maybe lost as I've sort of become more rote, and now to transpose into the lawyer's context, maybe I'm relying more on precedents, or I'm, as like you said before, I'm being safe. So even though I hate the way this sentence is constructed, a court has adjudicated that this is the magical incantation that one needs to put in a contract in order for it to be, judgment proof. So even though it would be way clearer if I said it this plain English way, I'm going to say it this way. Going back and having that kind of conversation with your former self is so healthy. If you don't do that, then to me, that means that you think the status quo is just fine. You don't need to get any better than you already are. And I think lawyers, and there's some research that will back me up on this, lawyers, I think, have, let's say, a bit of overconfidence about how good their writing is. And so it's very healthy for them to polish their skills. And when I say polish, I'm not even suggesting that it's a remedial exercise. Certainly there are people whose skills require polishing because there's work to be done.
Mm-hmm.
So you're a 200 hitter and you want to be batting 250. But there are people who will finish their careers as 300 hitters who will still continue polishing, right? The other thing that I'll say, and tying in the idea of judges, is as a lawyer progresses through her career, the kind of writing that she does hopefully will evolve. So you have to continue to develop your skills because the kinds of things you're being called on to produce will change. So when you're starting out, you might become a really adept affidavit writer, but that's not necessarily the same as being a really good brief writer. And being able to write a motion brief is not necessarily the same as being able to write an appellate brief. And certainly, I mean, I think to a person, every judge I know, and I know a lot of judges, will say, I wish I knew then what I know now from the other side of the dais. And part of what I can do is to sort of be that translator, to tell lawyers, this is how a judge actually is going to be reading this thing that you've written. We want to get ourselves in our readers' heads. Here's how you can actually do it. So as the course of your career changes, the idea that you wouldn't need to branch out and strengthen certain skills and polish others, I think is probably a recipe for mediocrity.
It's interesting to hear you talk about evolving writers. And one thing when I think of, we were talking about creativity and stuff, and one thing that Jake and I have talked about is they talk about writers developing a voice. It's hard to get away from some of those conventions and get into actual expression. And I was curious if you think that do lawyers go through that same thing? Do they develop a voice? Maybe not necessarily where it's going to be like a conversational thing, but a way of doing that or a style that makes them a better legal writer.
It's a good question.
I think yes. It's so tricky. It's a very fine line to walk. So it's a really big question. I'll narrow it to litigators. Is that fair? So people who are writing briefs for a court.
Sure.
How do you bring your own voice to that? Because I think when you're writing, I would distinguish that from when you're writing to a client, for example, or when you're, delivering speeches. Then I think you can certainly have more of a voice. And it's nice to see lawyers on Twitter. It's nice to see their authentic voices. When you're writing for a court, it's a fine line because you have to be obviously respectful. You have to be candid. Judges don't like hyperbole. They don't like sarcasm. They don't like flights of fancy. So you do have to walk a relatively conservative line, I would say. But having said that, you can choose to be ruthlessly clear, ruthlessly helpful. You can tell the judge exactly what they need to know when they need to know it. And really thinking that through is, I think, if that's the kind of professional persona that you have adopted, I'm the person, I am a respected voice because I will tell the judge, I will tell it like it is. I'm not going to overstate. I'm not going to understate. I'm not going to oversell. I'm not going to undersell. I'm going to pitch it sort of right down the middle. And then you develop a reputation because while every case is a one-off, hopefully in the course of your career, it's going to be a matter of repeat play with the court and with other lawyers and with clients. So you want to develop that reputation as somebody who is concise and clear. And that's not to say that you can't have a distinctive voice, but what counts for sort of being distinctive in law is, and you're going to laugh at this, but like the raging debate, it might be, can you use a contraction? Right?
Right.
Because like, is that level of informality okay? That might be just that single act of, yeah, I'm going to write this in a way that I'm hearing it in my head, and in my head I hear contractions, so I'm going to put them down on the page. That itself is a kind of self-expression that is controversial.
Interesting.
I'm just getting like, I'm just seeing some kind of like somebody that lives on a Quaker farm, you know, that's like everyone's just like quaking, you know, and then this person like cruises in on a low rider, you know, with a hat, and like that's a contraction, you know, comparatively. You're like, whoa, slow down, guy. Like, let's not, it's does not doesn't. I mean, is that kind of what you're talking about? A contraction?
Well, yeah. I mean, so Justice Kagan of the U.S. Supreme Court uses contractions, and it's noteworthy. Now, maybe we're playing really inside baseball to know that kind of thing, but
honestly, the Supreme Court is what made me think of that question, because I was thinking that like when you get to these
Gorsuch style,
who are they're yeah, I mean, like Ginsburg doesn't write like Kennedy, you know what I mean? So
yeah.
It's very, very, I think, evolved and personal at that level.
Yeah, and it's a really fun parlor game. If you're, well, an enormous nerd, I guess I should qualify that by saying it's fun amongst a very boring small subset of people. If you have a decision that's written by the court, to try to figure out who actually wrote it, because you can tell by the style.
So well, let's keep going. You wrote to us, you know, earlier before we got into the interview about the single biggest barrier to good written advocacy. Can you explain what that number one barrier is?
So this is not an idea of my own. I've borrowed it from Steven Pinker, who I would also commend his book. He wrote a book recently called The Sense of Style, and he talks about the curse of knowledge. Have you read the book?
Yes, love that book.
Great book. So, you know, the curse of knowledge is actually a term that comes from economics. And the idea is that in a negotiation, so let's say you and I are negotiating over buying my used car, which one of us in that negotiation is in a better position to negotiate for a better price? You would think it would be me, because I have superior information about the car than you as the seller. But what economists found is that it's actually the reverse. It's the person with less information who's at a strategic advantage in a negotiation. And the reason is because as the seller, I know that I've, you know, detailed my car within an inch of its life, but I also know that it actually, you know, took a real beating on the back roads when I was taking it up to my cottage, or, you know, there was that time that my dog shed all over the back seat or whatever it is. The curse of knowledge is not just that I'm at a disadvantage from knowing that. It's that I'm at a disadvantage because I can't imagine what it's like to not know that. So I'm factoring in that negative information when I'm setting my price and when we're negotiating. Wow. It's the idea that you can't imagine what it's like to not know the thing you already know. If you isn't that, it's cool, right? So I mean, think about the smartest teacher that you had in high school was not necessarily the most effective teacher you had. Sometimes it's not a reflection of how smart you are or how much you know. Sometimes you know too much to be able to understand where somebody who doesn't already know what you know might be struggling. That's kind of that's the barrier.
Yeah. Well, I mean, that's kind of that thing that, like, you know, why doesn't everybody with an MBA go start a business? Because there's, you know, they know all these different details and they don't have that kind of thing of like, look, I'm just going to go do this.
But go back to the creativity. Why does that person not move away from the canvas? Because they know Degas, they know Picasso, they know all of these different abstract, Cubism, Impressionist. and they say, well, what is this? Is it that? And then a person who just walks by the painting says, that sucks, or it looks orange, and, I think, you're so lost in these weeds, like as a musician or a jazz musician, which is like the eclectic nerdery of music, not as far as Baroque musicians, because that's, if it ain't Baroque, don't fix it. But I'm sorry.
He had to go there.
Oh my gosh.
But I it's something that I've mentioned before on this show, is that you don't know what it's like to not know. And this kind of goes into ad copy, like copywriting. Like, I think what you're talking about is know what your recipient needs to hear, know how they want to hear it. Don't deliver too much English on it. Don't spin it too much. Give it to them, in the context that they need it, and get out. It reminds me of advertising principles and marketing principles, where people create an ad for their company, but they know everything about the company. So when they create an advertisement, it has all of that inborn knowledge, but without that, it doesn't make sense. But for the person who signed off on the ad, is like, perfect. This is our tone. This is it, but you don't know what the audience wants to hear. You're not sure how they're going to receive it. So, I mean, this back and forth is so common in advertising and copywriting and marketing. So.
Right. And that's a great analog, because what I consider to be the cardinal rule of legal writing is you always write for your reader. And sort of turned around, and I like to tell this to law students, it's not about you. So you have to ask, what is it that they know? And the truth of the matter is, especially when you're writing, you're writing for that senior lawyer who's doing your performance review next week. You're writing for a judge who's, very learned in their area. Every reader who you encounter is a lay reader when it comes to what you're writing about, because they wouldn't have asked for your opinion if they already knew the answer. And that's something that law students need to wrap their brains around, is that once you get out of the pedagogical exercises of law school, people are genuinely asking for your opinion about something they don't already know the answer to. And so your job is to put yourself in their head. The shoes is the wrong body part. You put yourself in their head and you say, what is it that they need to know? And not just what do they need to know, but what order do they need to know it in?
Oh.
Because Pinker is really great on this, right?
Mm-hmm.
You have to be you have to tell your reader why something is important in order for them to understand what's coming next. Steve Armstrong, who's this brilliant writer, he teaches legal writing. He talks about building containers for your reader along the way. So if you imagine that you're hosting a dinner party and you offer your guest a drink, you wouldn't direct them to the kitchen sink and say, stick your head under the faucet and just let the water pour out, right? You'd offer them a glass, and then you would pour the liquid in. And so when you're writing, it's the same. You build a container for your reader, and then you put the information in, and then they can actually hang on to it instead of letting it just spill out over onto the floor.
I love that. Yeah, and primacy is one of those big the way in which you tell someone something affects the way they interpret the information. They did a psychological study in the same field, and they described the same person with the same adjectives, but they reversed the order. So one group they said, well, help me describe how do you think this person is? They're intelligent, they're smart, they have stamina, they're a little, they lack a little discipline, and they're kind of hard-headed. And then they just reverse the order. They said they're hard-headed, they lack discipline, but they're intelligent and all that stuff. So the people who heard the negative stuff first definitely had a different view of this person. So you have to be aware in the way you pack those containers and what order it is. And metaphors are really the only way you could really get someone to feel it. And I like that it's not the shoes. Why are we walking around in other people's shoes where we need to be inside their heads? I think that's really, really
And by the way, one of the ongoing debates in judicial writing is, do you put your bottom line decision in the overview or the introduction of your reasons.
Oh, yeah. And that could
Because
change the whole way they perceive the entire brief.
Right. So, I mean, on the one hand, the reader you'll be able to lead the reader through your decision if they know what you decided, and then you're leading them down the analytical path of why you decided that. That's one school of thought. Another school of thought says it looks like you've prejudged the case if you put your decision right up front, and it might turn a reader off. And I don't think there's a right answer. I just think it's something to be aware of on either side.
Yeah, I think it's brilliant. So switching gears from writing, we talked a little bit about life law balance. You mentioned the necessity to retaining more women in the legal profession and that the term work-life balance should be abolished. So tell us more about your thoughts on this.
I have two caveats or disclaimers because I'm a lawyer, so of course I do.
We're all about
that. The first is that I can only offer my perspective, and these are very fraught conversations, so I want to be really respectful of that and have people understand that I'm only offering my perspective. That's the first, I guess. And then the other is, you're quite right. I hate the term work-life balance, and I'm going to tell you why. As an editor, it is terrible practice to flag something that needs to be changed and not offer an alternative. And I confess that I don't have a good alternative for work-life balance. I think that term is so permeated into our discourse that to dislodge it and replace it with something else will be very difficult, and I'm not sure what that thing would be. So with those sort of caveats in place, I hate the term work-life balance because it's both under-inclusive, it's over-inclusive in some way, and it's also misleading. So it's, I think, over-inclusive because it's certainly true that we are all entitled to balance in our lives, and that's it's an essential ingredient of wellness, and we're all entitled to that. What work-life balance as a term does, though, is it homogenizes the experiences that we all have as on the work side. The life side is not the same for everyone. And I do think that we need to have a different way of talking about this. When what we're talking about is the lived experiences of working parents. So because I can only speak from my perspective, and my perspective is as a working parent. Mm-hmm. If you look at and so I'm going to nerd out on you for a minute, the etymology of work-life balance is ancient. It's Aristotelian, and the original translation is work-leisure balance. And the idea was that to be, a good person, of course, parentheses, read man, you needed to balance necessary labor, which was stuff like commerce and war making, with honorable pleasures like art and philosophy. That's the work-leisure balance. Mm-hmm. It's only in the last 30 years, really, that work-leisure balance became work-life balance. And the best that I can figure, and I'm now cribbing shamelessly from a really good article that Eric Devaney wrote in a blog on HubSpot. Mm-hmm. It's only in the 80s that it became work-life balance, and it was a response to like a phenomenon of workaholism. And that, if you figure the era, if you think back to like the movie Wall Street, that kind of thing, again, we're not talking about balancing the demands of work and the demands of parenthood. It was meant for a very different audience, right? Work-life balance doesn't capture the quotidian labor of parenting. And so when we talk about work-life balance, I think it evokes these sort of warm, images of, tender snuggles at bedtime and like little pockets of time during the day where you are, quiet and calm with your children. That's not what it is at all. Parents know that.
Yeah.
And so I think we need a new conversation about it.
It doesn't necessarily encapsulate all family types, because I read something on more the African American community, lawyers of color are like, their family networks are a little bit more wider ranging, but they're having problems saying I have to go visit my cousin, or it's my cousin's wedding, or something
I read
like that.
Too.
Yeah,
And
I thought that was fascinating.
I thought that was a really important contribution to the conversation, that depending on what your cultural background is, what your what your situation is, it's not just about parenting. You may well be caring for an aging relative who is not, a first degree relation, because we can all understand, my father is in the hospital or something like that. But if it's your grandmother who raised you, that is no less, completely imperative demand on your time than if it was your mother or your child, for that matter. I guess what I'm getting at is the idea of work-life balance. That life part, and maybe this is subconscious, and maybe it's just me, but I've always read that life part as being somehow discretionary, which parenting and other family obligations are not, and also transient. And parenthood and other family obligations are also not transient. So I often hear of work-life balance in the context of young parenthood. And I have some bad news to deliver to people who might have, babies or young children. I have slightly older children. I'm so sorry to say this for those who don't know yet, the work changes for sure. The physical demands of parenthood change, right? Like kids become autonomous beings, but they need you more, not less. They need you there at dinner. They need you there for help with homework. They need you just be a presence in their lives as their peer group becomes a more dominant influence. It's important for the parent to stay in their faces as, if not the dominant influence, at least a significant influence. And then there's just all this stuff, right? Like, kids don't get sick only on the weekends, and, you can't take them to dentist appointments only after hours. And that's just the routine stuff. Forget about if you have, a family member who you're responsible for who has medical needs or other needs that need to be attended to. And so that's why I'm an advocate of what I'm calling radical flexibility. And what I mean by that is, of course, people want to keep core hours. I mean, people want to be in the office. It's nice to have colleagues. It's nice to be able to bounce ideas off people. It's important to be present so that you can be in meetings. But the idea of, that you're looked on askance if you come in at, 9:15 when somebody else was in at 7:30, well, maybe like someone has to get the kids to school, right? So just the idea that what matters is the timeliness and the quality of the work, and that should be the metric by which people are, evaluated and valued, and not this FaceTime nonsense, frankly.
So that's interesting, because I've always looked at it like that the way that technology is now, I'm using technology to kind of make the point here, but the way technology is now has made it so that, this work-life balance, like we're calling it, has flipped it in favor of work. You're never really away from the office because you have your phone. Everybody's got email. You can't get out of it. But it should be working for you the other way. You should be able to say, I don't need to be there because you can just send me a message. And I 100% agree with you that, life, it almost seems like people have taken this definition and said work is what happens in the office and life is what happens when you're off the clock. But you're absolutely right, is that doesn't mean that that's going to be any easier than what you were doing in the office.
No, I mean, it's often the other way around. I mean, especially lawyers are, there is a personality type. The stereotype is there for a reason, where we tend to be type A and perfectionistic and, really care about getting the job done right. It's very satisfying. Law is satisfying because you can do your best work out of the office. Especially, again, I can only offer my perspective. I didn't know anything about children until I had my own. I still don't know anything about, child development and so all of this, it's actually harder, right? Because this is not a job that we trained for, and yet it's the most important job that we have. The idea that the easier job is out of the office, speaking for myself, I have absolutely not found that to be the case.
Oh yeah. Well, and
totally.
I lived in New York during the hurricane, and I didn't go to work for like 2 weeks. And for the first 2 days, it was like awesome. We're like making cookies, we're hanging out, we're listening to music, having a good time. And then after a while, I didn't know who I was. I didn't know what I was doing. I didn't know what I stood for. And catch me the day before the hurricane. I'm like, screw this place. I hate working, and without work, I had nothing. And, I've talked to, baby boomer, late boomers, and they could totally retire. I was like, so what are you going to do when you hang up, your spurs? And they look at me like I'm crazy. They're like, what would I do for real? Like, I don't even know. Like, working is that life,
Yeah. And so I want to just toss it out there, because being Canadian, I think I can be, not me personally, but I'll stand in for a whole bunch of people who can represent a control group. So in the United States, a lot of the issues that we're talking about are tied up in policy choices like paid parental leave, healthcare, the fragility of social networks. We have a lot of that stuff figured out in Canada. Pretty much everybody takes an entire year off when they have a child. I'm speaking of mothers. But we have generous parental leave policies. So whichever parent you are, there's time off for you. And many employers will top that time up after the hold on to your hats, 35 weeks of employment insurance that you get.
Whoa.
Canadians don't have to make career choices based on healthcare, right? You don't have to worry about moving jobs or like doing what I did. I'm going to go off and try to just create a new business for myself, and because I didn't have employer-based healthcare. And Canadians also, tend not to move around as much. This is like gross overgeneralization, but the idea of you go off to university or college in one place, and then you kind of, hop around from there, and you see your family, your nuclear family, a few times a year. That's less common, I think it's fair to say, in Canada. So there are, I know this is a generalization, but a lot of the people I know are, within a reasonable driving distance of extended family. So to the extent that if those things were fixed in the United States, that the problem would go away. Again, I can only offer my perspective, but I'm not sure that actually is the answer. Sorry to be the bearer of bad news.
No, and don't be sorry, because we love Canadians. And we had, who did we have on the show last time, Paul? And we had like this whole thing. We're like, well, isn't this different? Because it was about mental health and law. And
Daniel Fish. Yeah. I asked him that big question about how, because everything is covered. He's like, actually, that's not the case.
And you were like, oh, so then we don't know. But we're getting schooled on this stuff. And for the whole part, you're wonderful with your disclaimers and stuff, and you're a lovely stand-in for the Canadian cohort.
I'm proud to represent the Maple Leafs.
Totally.
Right on.
So then this has been super fascinating. Unfortunately, we're out of time, so let's wrap it up. And how can people learn more about you, Caroline?
They can go to Mandel Coaching. That's Mandel with 2 L's. MandelCoaching.com, and they can follow me on Twitter at CJMandel with 2 L's.
Ten questions we ask everyone.
Here we go. 10 questions we ask everyone. Number 1, what was the last book you read?
A Higher Loyalty by James Comey.
Ooh,
nice.
He's a very good writer.
Number 2, what is your best habit?
So this is one that I'm working on, but I commend to everyone listening. I'm trying really hard to get in the habit of not sending people work emails after hours. So even if I'm checked back in and getting stuff off my plate, I don't want to be putting it on somebody else's plate during their time off.
That's a good one.
I've been trying to draft emails and then schedule them to go out in the morning, or I draft them and then I'll send them at another time.
I'm going to totally start doing that, because you know what I just realized? There's a certain level of consideration, because, even if you put in there like, hey, whenever you get to this or in the morning, but it kind of means I sent it now. So yeah, I like that's an excellent habit. I like that. I'm doing that one. Okay. Number 3, Facebook, Twitter, Snapchat, or none of the above? Twitter, totally. Number 4, coffee or tea?
As any good lawyer will tell you, I adopt a contextual approach. Depends on the time of day.
Okay. Then I will qualify that with in the morning.
Oh my God, coffee, obviously.
Okay. Number 5, what is your favorite place?
Florence, Italy.
Number 6, is Keanu Reeves a good actor?
Okay, anybody who saw Parenthood, the 1989 movie with Steve Martin, knows the answer to this question, and it is an unqualified yes.
Totally.
Yes. Number 7, what was your first job?
Day camp counselor.
Number 8, what is a skill you have outside your current occupation that you incorporate into your work?
I don't know how outside my current job it is, but I was a good lawyer. Because I worked at the court, the court is a generalist court, hears all kinds of cases in all areas of law. So even though I am not technically practicing law anymore, I can help people with their writing, with their legal writing, with substantive knowledge. So I can kind of look at where the substance meets the style, which I think is real value added.
Nice. Yeah, no, that fits. Number 9, what sites, blogs, or newsletters do you regularly check in with?
Oh, so my daily diet is print local newspaper, and then online New York Times, Washington Post, and whatever people direct me to on Twitter throughout the day. And weekly, the New Yorker magazine in print. Doesn't get better than that.
Okay, we've made it to the end. Number 10, after a long day or a long week at work, how do you relax and unwind?
So I grew up this way. My kids are growing up this way. This ties back to the idea of social networks that we talked about before, familial networks. In my family, Friday night dinner, and I mean this only a little bit as a pun, is sacred. Every Friday night from the time I was a little kid, we would spend with my parents and my grandparents. And that's how my kids are growing up too. I'm 5 minutes away from my parents, and we go over every Friday night. My mom makes an amazing meal. And it doesn't matter what anyone has on their agenda. Friday night, you leave work, you come for dinner, you don't go out with friends, you don't go out to restaurants, you don't work, you don't travel unless you can avoid it. You can see everybody visibly exhale. Once a week, just to have that protected few hours is magical.
For show notes, links, and info, go to www.consultwebs.com/lawsomepodcast. Be sure to leave us a review and rating in iTunes or wherever you find the you listen to. Until next week, stay lawsome.
Bye.